This is English shorthand dictation number 335 and the dictation speed is 120 words per minute. Ready? Start. The emergence of a welfare state led to the state bearing the culpability to take care of people's socio-economic needs. All the aspects of this responsibility cannot be endured by a single branch of the state, especially one as underfunded as the judiciary. This created an opening for the executive to assist the judiciary by performing many quasi judicial functions like levying of fines, penalties, etc. The legislature decided to ease the load of problems faced by the Indian courts by instituting provisions under Articles 323A and 323B of the Constitution of India 1950 to form adjudicating authorities exercising quasi judicial powers, and these evolved into tribunals. The Supreme Court, in the case of Bharat Bank Limited versus employees, stated that all adjudicatory bodies performing quasi judicial functions are not tribunals. Only those governmental bodies which pass the basic test under Articles 136 and 227 of being vested with states judicial power under a statute or a statutory rule can be classified to be a tribunal. So, on one hand, a court derives its power directly from the Constitution, whereas tribunals derive their powers from statutes enacted under Articles 323A and 323B of the Indian Constitution. Thus, the judiciary as an organ is free from legislative control. They can interpret the statutes enacted by the legislature howsoever they desire and can render a judgment which, according to their own viewpoint, is correct. However, a tribunal is a child of a statute which has been specially enacted for its creation and is bound by the statutes that have created it. Given that they are still a part of the judicial system, it is imperative to ensure that they are not decorated with unfettered power. There has to be a system of checks and balances over their functioning, and a high court must be given authority over their working. Tribunals are formed by the legislature through a statute to solve particular kinds of cases pertaining to a particular department of the government, like the Income Tax Appellate Tribunal or the Appellate Tribunal for Electricity. These departments receive the funding to maintain their infrastructure, support, services, workspace, etc. from the government, which can be highly influential in regard to the working of these tribunals. The government officials may try to influence the decisions being taken by these departments in a way that would favor the state. This was a problem in the case of Union of India versus R. Gandhi, where the sponsoring agency had appointed its own director as a member of the selection committee of the NCLT. This allowed the department to select the kind of officers that would rule in the department's favor. It was also observed that the civil servants who are inculcated as part of a tribunal are aligned with the interests of their own department. This creates bias towards the welfare of their own department, especially when it is one of the parties in a dispute. To remedy this situation, the court proposed a new four-member selection committee, including the Chief Justice of India or his nominee, a senior judge of Supreme Court or a High Court Chief Justice, Secretary of Ministry of Finance and Company Affairs, and Secretary of Ministry of Law and Justice. This committee would be free from any departmental members interfering in the selection of the constituting body of the tribunal, ensuring its independence. The same issue also came up in the case of Madras Bar Association versus Union of India. A five-judge bench of the Supreme Court declared the National Tax Tribunal Act 2005 to be unconstitutional. The court overturned the provisions which allowed the central government to decide the venue, setting up of branches, transferring representatives, etc., of these tribunals. The objective of this statute was to strengthen the executive's dominance over the tribunals, compromising their independence. Government itself, being a stakeholder, added to the prospect of these adjudicators indulging in bias. It was also held that constituting a tribunal of a majority of executives officers rather than judicial members would reduce its ability to act independently. Contrary to these tribunals, a high court is independent from the influence of any other branch of the state. They are not answerable to any particular department of the government and have the authority to direct the legislatures and state governments to act in a certain manner. The only authority over and above the high courts is that of the Supreme Court of India. Robbing the high courts of their power would increase the work pressure on the Supreme Court, as they would have to indulge in matters that could have been decided by the High Court. High courts have a considerably greater number of judges and can easily tackle increased workload. Thus, having a high court overseeing the functioning of the tribunals as well as the trial courts is ideal. The 42nd Amendment to the Constitution of India 1950 brought about a severe change to the provisions of the Constitution, which severely diminished the powers of judicial review exercised by the High Courts and the Supreme Court. There were two principal changes curtailing their power. First, Article 227(1), which restricted the authority of the High Court to exercise its power over all courts subject to its appellate jurisdiction, excluded tribunals from the provision effectively. Further, Clause 5 was inserted to the article, which withdrew the power of the High Court to question or review any judgment of a lower court unless one of the parties prefers an appeal or a revision. The second change was the incorporation of Articles 323A and 323B, which empowered the Parliament to pass laws for creation of administrative tribunals which would only submit to the jurisdiction of the Supreme Court. In the guise of taking the case load off of the high courts, the legislature attempted to increase the control of the government over the judicial system. Ousting the authority of the High Court would have allowed the state governments to influence the decisions of the tribunal to be more favorable to their cause. As mentioned above, the Supreme Court would be unable to deal with this bias of the tribunals due to the exorbitant amount of work that would inculcate for them. However, some relief was granted to them when the Constitution 44th Amendment Act 1978 was enacted.